Hi, this is Steve Dale with the Dale Law Firm here, and we're recording this in March of 2019. Today we're going to talk about special needs trust with a focus on mental health issues here. And so what we're going to do is go through the program, and then when we're done with the formal program, we'll be taking questions from the audience and also from those that are watching online if you're live, okay? And so with that, I do want to mention, for those of you that are interested in being on our mailing list, you can get a notice of future programs if you'll email amy@dalelawfirm.com. Anyway, let's go ahead and get started with this. Part of this is, and you will have access to a soft copy of our Achieving Independence Guide. Part of what this guide is meant to do, and even what the workshop is meant to do, is that we're kind of going through a step-by-step process of how do you plan for persons with disabilities, all disabilities, but today's focus is going to be on mental illness here, and how to go through the process, how to work with your advisors and all that to set up what I call a private social service system. So you're going to see some references to chapters in the guide, once again, something that you'll get access to here. And the objective as we go through this is really to try to take the process and break it down into a step-by-step process. Now, I'm going to begin this with my favorite subject, which is talking about myself here. Who am I? Who's the Dale Law Firm here? And a little bit about us, and then we'll get into the substantive part of this. Now, I know when people start talking about doing a special needs trust, normally people, if you ask them what is a special needs trust for, they're going to say, well, it's to present it's to preserve somebody's eligibility for SSI, Medi-Cal, IHSS, and all of those programs. Now, it's not that those programs aren't important here, but focusing only on preservation of benefits fails really to address the big picture. You know, part of this, and I'm sure most of us can agree to this, is really our true objective should be, maximizing quality of life for a person with a disability. And today we're going to focus on mental illness. And public benefits is just one part of the process here. Just getting a little bit into our background and a little bit about the Dale Law Firm. I am Steve Dale of the Dale Law Firm here. And actually started this practice about 30 years ago, and we're kind of an unusual practice, but because all we do are special needs trusts. I personally was actually a psychiatric technician for 17 years before we started the Dale Law Firm here, and I came from a family of psychiatric technicians, folks that worked in California's institutions for 3 generations. So basically, and we're going to talk about the disability community, I actually was born in the disability community, and when I was a young man, it was very common. My family worked at Agnew State Hospital here. It was very common that workers would have their children actually come to the hospital, and I actually spent a good part of my childhood on the grounds of Agnew State Hospital. Now, as we talk about hospitals and deinstitutionalization, I want to make it clear, I am not in favor of opening up state hospitals. What I am interested in is, the shutting down the hospitals and the promise that was made that they were going to replace the hospitals with all these different programs dealing with mental health in the community. And early on in the process, in the 1970s, we had a robust mental health community program. Now, where that program is, I have no idea. I have to say that dealing with folks with loved ones with mental health issues is the most difficult group we work with, because the problem is it's oftentimes very hard to find those services. So with that, I originally got started doing civil rights work for a group called Disability Rights Education and Defense Fund as an intern. I was fortunate enough to work with many folks that are now leaders in the disability community, including Ed Roberts and other folks like that. And after working in that, had decided that I wanted to get involved into estate planning. And so a lot of what I'm going to share today is basically 30 years of experience here of doing special needs trust, not just setting up the trust, because setting up the trust, quite frankly, is not the hard part. The hard part is actually making the thing work, okay? The last thing about this as we talk about this, and as we get to the last part of the program, we're going to talk about the whole process, if you decide to work with us here, of filling out the intake sheet and what is the whole process of actually doing a trust through the Dale law firm. I'm going to mention this, okay? Most of the work that is done here is done by Jennifer Stenberg who is my associate, who is a disability rights advocate in her own sense. She was an ADA attorney before she worked for us, and actually worked for George Miller as George Miller's disability expert. So she is somebody who, and she also here has a sister with a severe disability. So when you work with Jennifer on her drafting team, and we'll talk a little bit about that, even though I'm not the one that's going to be working with you, she's incredibly experienced. And once again, I do most of the programs and she does most of the work. So that's how it works. Now, for those of you that are in the room, this is not going to be that hard for you to imagine, okay? But I always like to kind of lead off when we're talking about planning for a person with a disability, just kind of set the tone of what it is we're trying to do and what is the challenge that we're trying to address. So part of this is, imagine that you have a loved one with a mental illness. Today, I'm going to introduce you to Kathy. Now, Kathy, in a way, doesn't exist, and on the other hand, there's thousands of Kathys out there. So let's say you have a daughter named Kathy who has schizophrenia. Now, whether it's schizophrenia, bipolar disorder, whatever it is, you know, once again, what we want to do is talk about the challenge when we're doing the planning. Now, let's say that Kathy is 17 years old, okay? And let's say that you're going to get your trust done and get this all taken care of. So we're going to make sure that Kathy is going to be taken care of for the rest of her life. Now, let's just assume that Kathy is likely to need some level of assistance for the rest of her life. Now, one thing that's important is that, you know, when you've met one person with schizophrenia, you probably met one person with schizophrenia. Now, there's many ways that schizophrenia, for instance, or bipolar disorder, or any of the other mental illnesses may play themselves out. And there's many people with mental illness who need minimal assistance. There's many people with mental illness who need maximum assistance. And then the thing that often when we're talking about dealing with somebody with a mental illness is, it's very common that they'll have periods where they do very well, and they'll have periods where they're not doing well at all. So one of the things that sometimes is challenging when you're dealing with somebody with a mental health diagnosis is it's not a static situation. Things change and all that. So you come to the estate planning attorney's office. So let's say you come to the Dale law firm, and you want to get one of these special needs trust things done, so that in the eventuality of your incapacity or death, you want to make sure that Kathy is otherwise provided for, okay? Now, the other thing with this, and I know that statistically for folks with schizophrenia, they tend to have a shorter lifespan, but let's assume that Kathy's going to have a normal lifespan. Here's the challenge we're going to have. Normally, her actuarial life is going to be that she's going to live until she's 87 years old, okay? So let's say you're in San Francisco, this makes it even more possible. So you get your whole plan done, and you walk out in the street and you get hit by a bus, which in San Francisco is very possible here. And let's say, we don't say that you persons pass away or die, we would say your trust matures. You're dead, okay? So here's the challenge. Here's what we're trying to do. How are we going to provide for Kathy for the next 70 years here? And what are the challenges we're going to have to deal with? Well, first off, normally we would go through, if we were able to go through the full workshop, and we're going to go through most of it, but we'll make sure that you have a link to it here. But normally we'll go through a whole presentation on the basics of public benefits, the basics of SSI, Medi-Cal, SSDI, Medicare, and all of that. And for those of you that are watching, we'll make sure you have a link to a segment that deals with public benefits. Now, here's the question for you. How many people think that the SSI rules will stay the same for the next 70 years. And I've never had anybody paying attention put their hands up. Usually if you put your hands up, it means that you're not paying attention. So if we do a trust for you, if our focus is preserving Kathy's SSI for the next 70 years, is that trust going to do its job? And the answer is no. So we better make sure that trust is going to be able to adjust to changes that are going to happen with the public benefits, okay? Dealing with disability is never a static thing. Social service systems are going to change. And as we get to the later on in the program, I'm going to get into a whole segment about what's the difference in planning for somebody with a mental health diagnosis versus a developmental disability. Well, one right here is that in California, if Kathy had autism or a developmental disability, she would be entitled to a plethora of programs by the regional center. She would be entitled to a full scope of services. Because she has a mental illness, there is not a full scope of services to be had. And if you know where I can find a full scope of services, if you would let me know, that would be terrific. And that's one of the more challenging things. Now let me just mention this from the beginning. And the camera's not on you folks, so nobody's going to see this. How many of you are members of NAMI? Okay. By the time we're done, I want to talk you folks into all becoming members of NAMI. Our hope of changing the social service system, our almost only hope is the National Alliance for Mental Illness, and NAMI is the only program I know that advocates effectively for our folks. Right now, as far as I'm concerned, the services for mental illness can only get better. It's hard to imagine them getting worse. There's only one direction to go, okay? For developmental disabilities, it's going the opposite direction, and let's hope they don't meet in the middle. Now, here's the other thing. Her condition may change. I will tell you, being in the mental health world virtually my entire life, I have seen major changes, and I've seen major changes in treatment. Some people get better, some people get worse, some people can have it controlled by medication, some people it may be controlled for a while here, but to think that Kathy is a static object is just a big mistake, because we can pretty much figure that Kathy's situation is going to change over time. Her advocacy system may change. Now, her most important advocacy system probably is you, okay? And part of what we're looking for when we're doing this planning is not that we can replace her advocacy system, but what we're looking at doing here is really working on trying to do our best to, supplement that, to replace that if you're not around to be that advocate. So along that line, advocacy is incredibly important, especially if Kathy is vulnerable, which many folks with mental illness are. Attitudes may change, okay? The attitudes that I have seen as far as changes with people with mental illness have changed dramatically. Now, in my father's and grandfather's day, the attitude was everybody with an identifiable mental illness should be in an institution. Well, those days are gone, and that's 95% good, okay? And as far as, for instance, NAMI and advocates working on trying to wipe out or at least diminish the stigma of being labeled with a mental illness, that's a really important thing. But don't think it can't get worse again. For many of us, and for myself as a former institutional nurse, think about AIDS, think about things like polio and that sort of thing. Oftentimes there can be hysteria about different disabilities and that kind of thing. So this is one of the reasons why advocacy for the disability community is so great. A lot of us certainly are aware of all the issues with guns and that kind of thing, and that can really change attitudes across the board. The amount of resources she may need may certainly change. Now, we have a couple of folks in the audience that we may introduce later who are professional. We have a professional trustee and we have a professional financial advisor. So I know they understand what I'm talking about. How much do we need to set aside for Kathy to provide for her needs for the rest of her life? And let me tell you a little secret. How in the hell could we possibly know, okay? Now, today, with the amount of supports or with the lack of supports, my feeling is what you need to provide is as much as you can within your resources here. Now, hopefully as time goes on, we'll see an advocacy for more community programs to support our mental health brethren here. But right now, the amount of supports we have is very minimal. Maybe as time goes on, that we'll start seeing acceptable supports like we did in the 1970s here about whether a special needs trust is going to work or not work is the choice of trustees. Okay, and one of the things we're going to focus on, in fact, I do this program, and I may be doing this again for our webcast in the not too distant future dealing with trustees, called Why You Shouldn't Make Your Daughter the Trustee of Your Bipolar Son's Special Needs Trust. It's not a good idea. Or what did she ever do to you? The point of this being is it's difficult for a sibling to be in charge of the needs of another sibling, disabled or not. Okay, it's a recipe for problems. Trying to do that when we're dealing with a significant disability, at least without a lot of supports, we have found has been something that is a great challenge and very difficult to deal with. But the next problem that we have, and for our trustee in the room, don't listen to what I'm about to say, can I name a trustee that I am absolutely confident would provide for Kathy's needs with the level of services that she needs and a level of quality that we demand for the next 70 years? And the answer is absolutely not. Okay, trustees are going to change, trustee systems are going to change, and all that. So as we start talking about trustees, here, that's probably the most important part of that presentation. We're going to make a really strong push for using professional management, professional care managers, and a new program we're working with called the Life Passage Planning Program. As with everything dealing with disabilities here, this is a changing environment. It is not static here, and it's going to change. So we need to make sure that whatever we do is going to be incredibly flexible so we can adjust to all these different challenges, and maybe some we haven't even listed here as time goes on. I hope that makes sense. So part of with the trust is try not to just think of it as a tool to preserve public benefits. Not that the benefits aren't important, but think of it more as an advocacy tool. For you parents and loved ones out there who have a loved one with a severe disability, do you remember what life was like before you had to deal with this? And I bet you don't. Okay? Disability is a life-changing experience. And oftentimes it's an experience, I think, that folks don't even really recognize, that it is not only is it changing your life, it's changing your attitude, it's changing how you look at things here. The issue that you run into is that oftentimes caring for somebody with a disability here is being that advocate, looking for resources, and probably getting more in touch with a lot of the issues involved here as far as the challenges with that. A lot of your family, they may be sympathetic, they may be empathetic, but they're not going through the same experience that you're going through, and to expect them to pick up where you left off is just not reasonable. In all too many cases, that level of care is not intuitive, and a skill that you have to learn, practice, and perfect over time here. As I like to say, in the disability community, we do one of two things when we have a loved one with a disability. We either embrace it and we deal with it as best we can, or we run as far away from it as we can, if we can. Some of us don't have that option. You're here obviously on a beautiful spring day after, by the way, it's been raining forever here. So you're giving up a beautiful afternoon here to learn about, dealing with advocacy for a loved one with mental illness. And I'm assuming that you're doing that because you are really interested in advocating for the best quality of life you can for your loved one with a mental illness. By necessity, family members can become quite adept at navigating the disability service and benefits system, even with the challenges that we deal with. Okay, so one of the things, I want to deal with is most folks, when they look at special needs trusts, or even with estate planning, they look at it as death planning. They look at it as, I want to provide for Kathy, if I got hit by the bus. Okay, well, the way it actually works is we don't all get hit by the bus, have the heart attack, whatever it is, along that line. One of the issues that comes up is, what if you become part of the disability community yourself? So I want to introduce you to a fellow named Ed Roberts. Now, many of you may know who he was, and I won't go into this a whole lot, but he certainly had a huge influence on my life. Ed Roberts was one of the founders of the disability rights movement, and once again, I was fortunate enough to get to work with him for several years before he passed away in 1995 here. But one of his favorite sayings was that the disability community does not discriminate. It will accept any of us at any time. So the issue with this, when we're talking about advocacy here, one of the issues we need to deal with is, what if you got Alzheimer's? What if you had a stroke? What if you had a mental illness yourself and it was debilitating? A good estate plan really should focus on giving instructions to your trustee, and your advisors on what are they supposed to do, right? And so with that, another way to look at this, and I have this in every one of my conference rooms, this is a definition of disability that comes out of a book called Loving Trust. Now, for those of you that look this up, the book is no longer in print. It's not a book about special needs trust here. It's a book about a philosophy of estate planning here. But their definition of estate planning in Loving Trust is one that I've just never been able to replicate. So their definition of estate planning is, I want to provide for myself and my loved ones during my lifetime, and upon my incapacity or death, give what I have to who I want, the way I want, when I want, and if I can, save every last fee, tax, or court cost possible. My clients will often point to this. They'll point to the fee part, of course, and we'll talk about fees later. But the point of this whole thing is, good estate planning isn't just death planning. It's dealing with what would happen if you become part of the disability community yourself. Now, for myself as an example, I don't have children who are at least diagnosed with a disability, and I actually worked in institutions, and I'm a little terrified of institutions. So my estate plan for Terry and I, my wife, basically what it says is, if there's a choice between taking care of me and her and our children, our kids are going to be fine, okay? But a lot of my clients aren't able to be that cavalier, okay? So part of what you want to do when you sit down with Jennifer and the drafting team, which is headed up mostly by Lysandra. So for those of you that work with this, you'll get to know Lysandra very closely. She's the paralegal who does the majority of the drafting work with that. Part of what you want to do when you sit down with Jennifer is that she's going to ask you about, what thoughts do you have about what would happen if you became incapacitated? These can be very difficult things to deal with because, most of the clients that I have do not have unlimited resources. I don't have unlimited resources here. If you do have unlimited resources, good for you here. But, part of it is very difficult, a decision about, what priority do you give about, taking care of your loved one with a disability, taking care of your own needs, taking care of your spouse, maybe taking care of their loved ones and things that matter to you. This is oftentimes one of the most difficult parts of estate planning, but it's incredibly important to address. Okay, so part of that is when you're planning for incapacity here, you have to balance your needs with the needs of your loved ones. And good estate planning really is going to be giving that guide, giving those instructions to your trustee. I will tell you, I was working yesterday on a trust, not done by us and done by a very well-respected attorney, but it's dealing with somebody who does have a mental illness as a child, and there are no instructions whatsoever about taking care of that person and taking care of everybody else. So it's one of those situations where we're just going to have to guess and do the best we can. So, for instance, if you had a stroke, a well-written plan should provide the trustee with clear instructions on what to consider in providing for your needs and the rest of the family. So let's just go into a little bit as we start digging deeper into what the heck is a special needs trust, okay? Now, a special needs trust isn't some sort of gift that Social Security and Medi-Cal and all of that created to help out families here. That's actually relatively absurd here. It's something that comes out of the Social Security laws that says if you have somebody who's disabled and is on SSI, Medi-Cal, in-home support services, and other related programs. If the person has more than $2,000 in cash here, it's going to disqualify them for benefits. So there were a number of attorneys years and years ago who looked at this and were dealing with families with loved ones with disabilities and tried to figure out, how can we create some sort of a vehicle, how can we do this in a way where we can create a trust where it won't interfere with their benefits. Well, this part of the law under Social Security says that for SSI eligibility here, a resource is any cash or personal property that the person owns or has the power to convert into cash and is not legally restricted from using this for his or her own support and maintenance. Okay, so if SSI recipient does not own an asset outright and is legally restricted from direct access to the funds, the assets are not considered a resource for eligibility purposes. So these attorneys, and I would like to say that I invented the special needs trust. I in fact didn't, although these folks are all elderly, so I guess when they pass away I could say I did it, but I didn't do it here. But the thing about it is they looked at it and they said, there's this thing called the spendthrift trust. Okay, spendthrift trusts have been around for 500 or 600 years. Okay, what a spendthrift trust is, it's a trust where you can leave money for somebody, but they have absolutely no control over the funds. And it's meant to keep creditors from being able to get to the assets. It's also historically something men did for wives because there was a day where women were not allowed to control assets. Those days are over here, and in fact in the Dale household it is quite the opposite, I'm here to tell you. Okay, but that's where they came from. So really, a special needs trust is just a glorified spendthrift trust. Now as we start talking about special needs trust, the core thing that all special needs trusts do, and today we're only talking about estate planning trust, is the trustee has sole and absolute discretion over every distribution. Because they have sole and absolute discretion over every distribution and the beneficiary has none, it's not counted as far as qualification for SSI and Medi-Cal. That is a special needs trust in a nutshell. Anybody see a problem with that? We're taking the most vulnerable person in your family, and what we're saying is you have absolutely no rights whatsoever to those funds. And actually, a functional special needs trust is going to be able to allow the trustee to disallow any request for any distribution, no matter how reasonable it is. And that's how they keep them qualified for public benefits. Okay, now we're going to talk a little bit about how to mitigate that. And there are some real righteous reasons in many situations where that may actually be the objective. There may be some situations where maybe that doesn't lead to the result that we want, but it's really important that you understand that a special needs trust, by definition, means a loss of control by the beneficiary. And a lot of what we're going to talk about is how we can kind of fit the trust to your loved one's situation, and also fit the trust to a situation where it may be that your loved one, under certain situations, is doing very well, and may have periods of time when they're just not doing very well at all. So it's one of those things that's going to adjust from time to time. A special needs trust basically is a contract. All it is a contract where the trustee has sole and absolute discretion. It's a spendthrift trust. And you know, part of this is by directing assets that would otherwise have gone to the disabled individual into the special needs trust. It's not going to be counted as an available resource for public benefits. You know, I know a question comes up, how much can you put into a special needs trust? Here, because I have a master's in tax, we work on occasion with some incredibly wealthy folks. So I think our largest special needs trust has about $30 million in it. You would think, why would you put $30 million in the trust? And as well, because they have it here. But the other one is, yeah, they're actually, in that case, there is a benefits issue, and we'll go through that in a bit. You might think that's kind of odd, but there's a program that this person can only get by getting on Medicaid, which is kind of odd here. But the other part of it is the trust is set up to protect the person with mental illness from being taken advantage of, losing it to creditors here, and to protect those funds. So there's many reasons. Benefits is way down on the list in this situation. Now, for those of you who don't have $30 million to put in a special needs trust, once again, part of this is that you can do a trust with any amount of funds, although as we get into this, we might talk about when does it start becoming impractical. So when we're setting our objectives, proper planning should focus really on achieving as much independence as possible, and benefits should never be the sole planning objective here. In fact, once again, I happen to serve as the trustee of the Golden State Pool Trust, and I had a beneficiary today where we actually elected we're going to be dropping this person off of SSI completely, because we're actually feeling that the benefits that this person is getting here is pretty minimal, and that the damage it's doing to that person just isn't worth the benefit. So there are some times where really sometimes qualification of benefits just isn't really worth it. It really depends on the situation. So a couple things about special needs trust. One thing you'll notice, there won't be too many in this, but in a lot of our webcasts, you'll notice a number that's often there called the POMS site. The POMS is the Program Operation Manual System. So the way I like to describe it is, if you've ever called Social Security, does it seem like they're reading a script? They're reading a script. And it's called the Program Operation Manual System. These are instructions to the eligibility workers. So a lot of times when we're doing more technical programs, we'll actually take some of the instructions to the eligibility workers, and we'll actually make them as part of our program, and we'll also teach you how to look them up. So this POM site is SI space 01120.200. Now if you Google that, I think my YouTube channel will come up first, I'm not sure, and after that will come up the Social Security website. But this is an example of what the POMS would say. So what it's saying is a supplemental needs trust, which is a different name for a special needs trust. It's entirely same thing. Is a type of trust that limits the trustee's discretion as the purpose of distributions. This type is typically contains language that distributions should supplement but not supplant sources of income, including SSI or other public benefits. Okay, so this is part of the instructions. So a trust can supplement here, and ideally, if you can, you don't replace public benefits here, although that's not entirely true. I will tell you that, for instance, dental care, as the trustee of the Golden State Pool Trust, you know, I know there are some decent Denti-Cal programs out there. I haven't found one yet. Here, I've heard of them, but I wouldn't send a loved one I have to a Denti-Cal dentist here. So, you know, for instance, we spend a lot of money paying privately for dentists, even though Denti-Cal will do a pretty miserable job in most. They'll look at your teeth and they'll pull your teeth. I think they'll clean them, and that's pretty much it, right? Well, you know, teeth are kind of nice. So there we go. So let's talk a little bit more about third-party trusts. Okay, so a third-party trust is established by somebody other than the beneficiary, the grantor. The grantor is the person establishing the trust. And what a third-party trust is, it's an estate planning trust. Here, there are two types of trusts, and we're only going to talk about one today. We're going to be talking about estate planning trust, where you set up the trust, and all the money that goes into the trust, or all of the assets, any property, whatever you put in that trust, here, is going to come from either family members. It can come from anybody but the beneficiary. Okay. For example, a third-party trust can be established by a grandparent for a grandchild. I happen to have a niece named Erica, which we talk about quite a bit here, who has Down syndrome. So in a case like that, we have set up a special needs trust for Erica Mott. And if you'd like to make a contribution to the Erica Mott Trust, you're welcome to do so, although I don't think I'm supposed to be soliciting that, so anyway, don't do it here. But it can be an uncle for a niece. It could be a cousin. We happen to have one of her cousins here. It could be a cousin to a cousin. It just can't be Erica to herself. With that, a third-party trust can have a lot of latitude. You can have multiple beneficiaries in a third-party trust. You can run it in special needs trust mode, and then you can run it in a different mode. You can do almost anything you want with a third-party trust. The only restriction is when you pass away, you cannot leave the assets to the drafting attorney because the state bar really frowns on that kind of thing. By the way, you can leave it to anyone you want, including you can leave it to nonprofit organizations like NAMI. Once again, the sole organization here, not the sole organization, the primary organization that advocates for persons with mental illness across the nation, but especially in California. So, by the way, just to mention this, even a small donation to NAMI, if you donate $10,000 to them, they'll get $20,000 worth of benefits. So, it's an excellent thing to do. So, jumping ahead a little bit, and for those of you that, decide you'd like to go through the guide, in Chapter 7, we talk about a 4-step approach. So, the process of creating a special needs trust can seem really daunting. And, one of the reasons we do these webinars, just to give you a heads up, is, and as we're going to talk about with our fee structure here at the Dale Law Firm, we actually give you a $500 discount, whether you watch in person or you watch online here, if you watch the webinar or attend one of our programs. Why do we do that? The reason we do that is that if you do this, we're not going to be answering every question, but there's a lot of key things we want you to really start thinking about before you sit down with Jennifer and her drafting team. Here are things like, what can the special needs trust do? What can it not do? Who should I choose as trustee? What are some of the models we're going to talk about? Who can I leave it to? All those different things. By watching this program, you're going to start off with at least a baseline of knowledge here, and you'll be better prepared when you sit down with Jennifer. And the other part of that is it's probably going to save a significant amount of time, here, which actually is a savings not only to you, but it's a savings to me. By approaching this planning as on a step-by-step process, because, once again, Jennifer and I in the Dale Law Firm, we do this every day, all day, okay? For us, this is not new. For you, hopefully this is a once-a-lifetime process here. And so what we want to do is we want to break it down into bites so you can take it on a step-by-step. For those of you who decide not to work with, which is fine, we're not the only law firm around, this will probably help you if you decide to work with a lesser law firm. Okay, so how do you know? Okay, so here's the approach we like to use that is best to meet clients' objectives. And we're going to break this down into 4 steps. The first step is we want to figure out what is it we want this trust to do. We want you to be able to clearly express your intent in your trust and related documents. So as I had covered, we want to be able to, because somebody someday is going to read this thing, and we want to give them some sort of clue as to what is it we want it to do, okay? After we do that, we want to choose a management system and team to carry out that intent. Okay, well that makes sense. So the next thing is you may be really clear about what it is you want to provide. You may have a really great management team, but if you don't put some funds in that trust, it's not going to do very much at all. So are we done? Well, here's the problem with disability. You're never done, okay? In fact, in this, you're never done even after you pass away or your trust is matured. We need to have some sort of a system that's going to update and review this whole process, not just for your lifetime, but for the lifetime of your loved one with a disability. So let's start breaking this down. Let's go to step 1. And for those of you that decide to read the guide, this would be chapter 8. So, providing supports for a person with a disability is not always intuitive. I will tell you, we get a lot of calls. We actually have several staff who spend most of their days just taking calls, and that is usually the primary person who does this here. And oftentimes these are folks who have newly disabled loved ones, and they're just trying to navigate through the system, and they're just trying to figure out, how can I do the best for my disabled loved one, or how can I do the best for myself here? And I know we get the same comment from many folks, is that they had no idea of the challenges that these folks have to deal with in their families until you actually are having to deal with it yourself. Going back to why advocacy is so important, this is something that the person you were before you had a loved one with mental illness, I can almost guarantee you had no idea how screwed up the system is, okay? And the challenges of just trying to find those resources and all that. So, especially as we start talking about working on management systems and things like that, it's really absurd to think that somehow you're going to take somebody from your family who's unprepared and you're going to throw them right in the middle of this and figure they're going to be able to negotiate this all in one fell swoop. I mean, that's just not reasonable. If you're a parent of a child with a disability, we've already done this exercise, consider how much this has changed your life. It has changed your life whether you know it or not. Disability is a life-changing experience, not only for the person with the disability themselves, but it's also for loved ones and their support systems. So one of the primary duties of a trustee is to comply with the intent of the grantor, okay? And so the problem is, if you have a bare bones trust, I will say we are the author of the Elder Council and the Wealth Council Special Needs Trusts. Which, once again, which are two software systems used by attorneys across the country. One thing about it, if you were able to look at them and look at other trusts, they are the largest special needs trusts in the land. Now, it's not that having a large trust is all that important, because I have seen very short trusts that basically all they focus on is keeping my loved one qualified for SSI and Medi-Cal. But we go back to this. If we have a trust that tells our trustee, a trustee who may never have known you, has no idea who you were here, and if all it says is keep my loved one qualified for SSI, how are they going to know what it is they're supposed to do? Without proper documentation of the intent of the grantor, the person creating the trust, that's you folks, here the trustee would not be able to understand the issues of the grantor. Now, one of the things you want to consider when you're working on documenting what your intent is to just be aware that this is one of what I call the disability equations, is isolation equals abuse and neglect. Now, one of the things with this here is that, once again, working in state hospitals, most of my time with folks with mental illness, my father doing it for 35 years, entirely for folks with mental illness, and my grandfather doing it for 40 years, entirely with people with mental illness. Here, I'm not absolutely sure that you're safer in the community if you have somebody with a severe mental illness than you were in the state hospitals. Yes, things like Willowbrook existed, and there were some terrible things that happened, but to think that moving people out of large institutions in the community will somehow magically keep them from being abused, you're just kidding yourself, okay? And the problem, one of the biggest problems I see in this, we start talking about case management, and the importance of case management here is really identifying situations where an abuse and neglect could come up here, and being really in tune to this. Now, for you family members, it's probably intuitive to you, but one thing as we're doing this and you're starting to document your intent and things you would like to encourage the trustee to do, is one of the single most effective ways to prevent abuse and neglect is to encourage the beneficiary to be involved, as involved as possible in a variety of community, and social activities of their choosing, okay? So the community movement, at least as it was designed by the initial founders, who would be disgusted with what actually happened. It wasn't just physically moving people into the community, it was having people be part of the community. It wasn't just to have them to be objects to be taken care of, it was to really give them the best chance of being full members of our society, and contributing members of our society to the degree that they can with the supports they need. So how would you do that? Now, for instance, and this is from somebody who's barely Methodist, okay? So it might be, like for instance, you can't say that if you don't believe in Jesus, you don't get any distributions. That actually would get struck down by the courts as against public policy. It is okay to say that if my child is interested in participating in my church, my synagogue, my temple, whatever it is, and if that's their choice, this is part of their community. This is, a community that I would like to encourage them to be involved in, and I would like you to provide those supports. Now, beyond the spiritual side of this, what's the other effect of this? The more your child is involved in community, the less likely they'll be abused and neglected, and also the more likely, if there's a problem, somebody's going to pick up on this. So really encouraging the trustee to keep them involved in their sports activity, involved with family, involved with whatever keeps them active in the community. As we talk about it, to help them address their vocational needs, educational needs, to get involved in the community, to do volunteer work. Not only is it a really nice thing to do, it's also something, it is the formula for prevention of abuse and neglect. And I know I keep pushing NAMI, which I probably should get a cut here, but NAMI has many programs here, so you should look at the NAMI programs in your community, because they also oftentimes will have things directly related to providing those supports to persons with mental illness themselves. The more your disabled loved one is involved in a circle of support, such as a religious community or social club or job or neighborhood organizations or family or whatever turns them on, the less likely he or she will be subject to abuse. Does that make sense? I think that makes perfect sense. It makes sense because I said it. No, it does make sense. Okay. So you need to clearly state your intent so that in the event the future trustee who doesn't know you is administering this trust, they're going to know what's expected, and a bare bones trust isn't going to do that. So how do we do this? Okay, and I'm just going to put all the slides up here. When you fill out your intake sheet, which we'll go through very briefly when we're all done here, and once again, all kidding aside, even if you use another law firm, this is a good exercise to go through before you sit down with your attorney here, so you can be really clear about what you're trying to do. The trust itself should have really broad information about what it is you're trying to achieve. Usually this is an Article 2 of our trusts here, and in that it's going to have a lot of information that we're going to ask you about what kind of vocational situation, if it's applicable, what kind of education, what kind of contact should they have with family, what kind of living situation is okay, what's not okay. Now what we don't want you to do is, we don't want you to have this thing be a 7 or 8 page article, because first off, nobody's going to read it, okay? Here, it has to be something that can be read. I would say if you can't read it in a minute and a half, you've overdone it, okay? But even if you have a loved one who's very young and you're really not even entirely sure what the future is, you have certain values and you have certain goals that probably are never going to change, with that. Now, with that, you can tie this to what's called a journal of, we like to call it a journal of intent. Sometimes they're called letters of intent. Here, we have to give you guidance on this. The reason we like to call it a journal is that if you think of it as a letter, it's like it's this document you're going to write. And I've had parents spend hours and hours and hours trying to write the best letter of intent, which is kind of absurd because, no matter what you write, it's out of date the minute you finish it, because it's going to change. So it's kind of like, start off by going with what is it that you intend, and then get into the woods a bit. Like, for instance, here's a good example. It may be that certain treatments have worked really well and certain treatments haven't. It could be like, psychiatric, especially psychotropic medication. Some of them are godsends, some of them are killers. Okay, some of them, they almost all have some level of side effects. So you may have a situation where one medication did very well, but maybe they tried Thorazine or Stilazine or one of the psychotropics, and maybe they had a terrible reaction or side effect or that kind of thing. You might want to be able to tell your trustee that as far as care is concerned, to be really careful about these medications. these medications have worked, these haven't, and that kind of thing. Now, it's not that these things are static, because as we all know, you could be taking lithium for years and years and years. It could work really well, and then actually I just had somebody where it just doesn't do its magic anymore. Time to change the medication. And these all of these medications have side effects, so that's one thing about psychiatric medications, is you have to be on top of it. So think of it as ongoing record of needs, and just keep adding to it, adding to it, adding to it. Some of my clients who've done this, I had a client who started this 25 years ago. She says that she goes back and reads this from time to time, and it's actually been very therapeutic for her, because it's actually logging not just her child's journey, it's logging her journey, And she says she may turn it into a book later. I hope she has kind things to say about her attorney, but we'll see. So, you've worked on this, you've documented your needs. Now we're going to work on our quest for the ideal trustee. So, now I'm going to offer myself as possibly the ideal trustee, because I'm an attorney, and obviously here I must be very special. We all know that's not true, but let's just assume this for a minute. So we have been looking for this character here for 30 years. We actually have not found this character here, but we have been looking for the ideal trustee. I will tell you, and for any of you professionals working out there and any attorneys who might be working with this, I know that any experienced attorney who does this work, I would say it takes about 5 or 6 years to really get enough experience under your belt to get a handle on this. You will come to the conclusion that the choice of the trustee or the choice of the trustee management system is the single greatest issue about whether this thing is going to work or not. Okay? So we kind of put a list together of who we think the ideal trustees are. So remember, I told you that a special needs trust is it's a spendthrift trust, where the trustee has sole and absolute discretion over every single distribution, and your child has absolutely none, period, end of game, we're done. So we need a trustee who's really going to use their discretion in the best interest of the beneficiary and always do the right thing. Well, being that I'm an attorney and I think very highly of myself, I'll give myself that check. Okay, so anyway, whether it's true or not here, that's something that's really important. And when you're dealing with mental illness, that's going to be especially challenging, because I will tell you one thing about being a psych nurse is, boy, you sure learn about tolerance. Okay, you learn how to literally have somebody spit in your face and ideally not choke the living life out of them, because, well, first off, that's not good nursing care and it's illegal here and all of that. But sometimes it really does take being able to take yourself out of the situation, kind of divorce yourself from what's going on, and really try to focus on the person and step back. And sometimes, once again, trying to provide for somebody with a disability, it really does take not only a lot of knowledge, but it does take, I think, a fair amount of tolerance here. We have a trustee out here. Would you say that's true? Yeah, I know that's true. Okay, so the other one is we need to understand public benefits and keep up with changes in the law. And the other thing with this is, on occasion, to make judgments about whether or not preservation of the benefits is actually worth it. Like I told you, today, we actually made a decision with the management team I'm working with to actually drop somebody off their SSI, because the lousy $150 a month he's getting is just not worth all the crap this poor guy has to go through. How many of you have loved ones on SSI? How many of you would like to be on SSI yourself? Yeah, not me. I would not like to be on SSI or Medi-Cal. I would not like to be one of my own clients if I could help it. It's one of those things you can. So, it's always, when you're dealing with benefits, it's a balancing act between the value of the benefits and the value, and what we're trying to achieve. Now, in this particular person's situation, we're electing to take him off of the SSI today so we can give him a little bit more latitude in his life. Here we think giving him some cash on occasions has some value. It may be, as time goes on, the benefits will become incredibly important, and then we're going to lock this thing back down and get him back on benefits. So in the future, it may be important. So it's not just understanding the benefits, and it doesn't necessarily mean the trustee has to be a benefits maven. Jennifer and I and much of the Dale law firm here, we deal with public benefits all day long, every day, okay? Do we know absolutely everything about public benefits? Absolutely not. I don't think there is a day that goes by here. Actually, the fellow that's running the camera over there, that's DJ, and he helps head up the part of the practice besides being our switcher guy today here. He deals a lot with intakes and a lot of those issues with folks, and we get questions every day where the answer is, I have never heard of that before, I don't know the answer. It doesn't mean you can't look it up. If you have a trustee, it doesn't mean they have to understand everything about benefits, but they need to have some resource where they can go when these very puzzling things come up when you're dealing with these things. They need to wisely invest and conform to all statutory fiduciary requirements. Okay. There may be no duty for the trustee to make a single distribution, no legal duty. There's a moral duty, but there's not a legal duty. But there is a solid duty that they have to handle the investments as a prudent investment. What the hell's a prudent investment? And if for financial advisors, it's basically, you know it when you see it, but it's basically making sure that the investments are not overly aggressive, are not overly conservative, makes sense for that person. And if the trustee does not invest the funds properly, it's very possible that they can be sued for mismanagement. But here's the other issue. Let's say you have two children, or for lack of a better term, let's say you have a typical child and a child with a severe mental illness. And let's say you divide your estate in half. Now, if your typical child loses their, receives their inheritance and blows it, well, what the heck, okay? They have a lot more options than your mentally ill child. If your mentally ill child loses those funds, there's virtually no way to get those funds back. So, you know, once again, you need to make sure those investments are proper. Special needs trust can be a very good tax planning tool in the right situation. So when we're dealing with this, it's really nice to have a team, a trustee group, who understands taxes and can make sure that the investments and the way the disbursements are being made can maximize the tax benefits of a special needs trust and minimize the chance of a negative tax consequence. The good news on this beautiful day is I don't have time to get into taxes, which I find absolutely fascinating here. You may not here, but that's something that, once again, we have a lot of information on that, and it's good if your team understands that. It's somebody, we need somebody, especially if they're on SSI, who can keep perfect books. Social Security intends to review every single distribution from every single trust. Okay, now, if you have a trustee who is logging every distribution and is doing it based on a set of rules which aren't that hard to follow, they're not intuitive, but once you get it, they're not that hard to follow, there's nothing to fear. If we have somebody who keeps books the way I would, if it wasn't that I am married to somebody who's does account work and keeps the books for me, my way of doing it is throw all the receipts into a box and we'll worry about it someday. If that's the type of trustee you have, you're going to have all sorts of trouble. So keeping those books is crazy important. We'll have questions at the end. The other thing that becomes incredibly important is that the provision of advocacy and the prevention of abuse. We're going to talk about care managers and things like that. I think in some ways, for many of the trusts that we have that are actually under administration, that advocacy, that oversight, you know, doing what you're probably doing already or doing the best you can is incredibly important. Now, even if I thought that I could do all these things, this is where I might personally run into a problem. And by the way, I don't think I could do all those things. They have to be immortal, okay? So here's the deal. If I become the trustee of your 17-year-old child with schizophrenia, I happen to be 67 years old. Will I be practicing when I'm 100? I hope I'm not practicing when I'm 137 years old here, and I probably won't be doing a very good job at that point. here. They have to be immortal. They have to outlive your child. Where are we going to find that ideal trustee? And here's the fact. They do not exist. It's kind of like a unicorn. It's a really nice concept, but as far as finding that in one package, it's not going to happen. So where are we going to get this ideal trustee? So here's how we do it. And how we do it, specifically doesn't really matter. So if you kind of took that list and you broke it into 3 spheres, how you break it up almost doesn't matter. But, what I'm going for is a checks and balance system. And as we start going through our models, keep this in mind. We might take the advocacy part, which would be dealing with the discretion, understanding the public benefits. I would count understanding the public benefits as advocacy because it's not just maximizing the benefits, it's knowing when they're of value and when they're not, and providing that advocacy and prevention of abuse. So we might put that in one sphere. We might put the accountability in another sphere, which is dealing with keeping the books here, maybe having insurance, being bondable, having some recourse if the investments are mismanaged or that kind of thing. So that, once again, the money for your loved one with a disability is very precious money, and we want to make sure as much as possible that money is protected, and we'll cover the immortality part. And on the financial side, we want to have, part of this dealing with not only the investments, but how to handle the investments in a way that not only is it appropriate for your loved one, but also we get the best tax benefits possible. So I'm going to go through a couple of models with you fairly quickly here so we can, get done ideally here and have some time for questions. Now, let me start with this. If you come in and say that I want my daughter to be the trustee of my son's trust or daughter's trust, that's what we're going to do, okay? Our job is to educate you. Our job is to, plant some thoughts so that you can, be better prepared when you get involved in this. I'm going to introduce you to a couple of models. Is this the only way to go? No, okay? But what I do want to do is introduce you to some models that we've been using for years that we think have worked pretty well, okay? And there's some practical sides to this. So model 1, which is something we use quite a bit. Here, by the way, which I've done incredibly well. I've had a terrible cold for the last 2 weeks and trying not to go into a coughing fit here or pour water on myself. Okay, so here, the trustee, which is the manager of the trust, is going to manage the funds, make the distribution, do the taxes, and keep records. Now in this, we're going to suggest that you might want to consider a professional trustee, and we'll talk about who these professional trustees are. So this could be a corporate trustee, it could be a private professional fiduciary, as we're going to talk about later, it could be a pooled trust. With that, there might be an advisory committee. Now, why would we want to have an advisory committee? Well, here's the thing that comes up. Let's say that you name Big Bank and Trust, or really big bank and trust who's going to be the trustee, here, and all that. Now, does it make sense for me to suggest to you to turn it over to Big Bank and Trust without any oversight forever? Because obviously Big Bank and Trust is going to do a great job and everything's going to be fine. By the way, we used to use A.G. Edwards a lot because they had been around for 180 years. And of course they'll always be here. Whoops, they're gone, right? We actually used to use San Juan Bank. They were absolutely terrific. Well, they're gone too, okay? And that sort of thing. So even using a bank, even using an institution, we cannot guarantee they'll be here forever. And the other thing is we can't change, no matter what we're dealing with, whether it's a private fiduciary, a corporate trustee, or whatever. They're only as good as the people that are working on your child's trust. So we have some trusts that are managed by corporate trustees where we think they're doing a marvelous job here. Is it because of the bank? No, it's because of the people, right? And all of that. Private fiduciaries we'll just touch on. We use a lot of private fiduciaries. We actually have a private fiduciary in the room right now. What a private professional fiduciary is, it's a licensed fiduciary by the state of California who's licensed to do trustee work, and we use licensed private professional fiduciaries a lot, okay? We go back to this. Can I guarantee that a private professional fiduciary is going to be able to provide the level of care we need for the next 70 years? And the answer is no. So, because first off, most of our private professional fiduciaries will not be alive for 70 years here. And it changes. Situations change. By having this trust advisory committee, the trust advisory committee is going to be able to not only give guidance on the trust, but also be able to amend the trust if laws change. Remember, I told you, laws and situations are going to change. So we might have something in the trust that says that we have to have a certain language in the trust because they're on SSI. It could be in 10 years there will not be anything called SSI. It may be a completely different program. So there may be somebody who looks at these trusts 20, 30, 50 years from now who's going to say, well, isn't that quaint? That's how they did it in the early 2000s. That's not how we do it now. We have to keep it up to date. Here's the other thing. We give them the power to hire and fire the trustee. Why would we do that? It may not just be that the trustee is doing a poor job. It may be that, and I'm going to introduce you to a new program later in this presentation, it could be that a new system, a new trustee comes along that's going to do a better job for less money. Why wouldn't we want that, right? Things are going to change. It keeps things competitive, okay? So by doing that, what we're suggesting is don't put your loved ones on the front line, but if you have the power to hire and fire, don't you ultimately have power over that trust? And that way you're not dealing with the day-to-day issues. Are we good? Well, here's the thing. There are some trustees who are very good at dealing with folks with mental illness, but the vast majority of these folks are not social service professionals. They're not social workers, they're not psych techs and that kind of thing. So oftentimes we hire a care manager, or what I'll introduce to you later is a program that's developing in the area called the Life Passage Planning Program. So we might use a Life Passage Planning Agency, which is a social service agency. So we might hire a care manager who's a private social worker or one of these care management agencies to go out from time to time, assess what your child's needs are, help identify what they need, and be able to report back to the advisory committee and the trustee about how things are going, what the needs are. Maybe there's a program that would be better. Most of these folks are pretty good at knowing what programs are out there and what the challenges are. By doing this, we have a pretty nice system here where we can have a trustee that is pretty well informed as what's needed, who has the oversight of the advisory committee and has the ability to be able to get guidance as needed by the care manager. Now the next one is very similar, and we'll go back to this. We deal with a lot of folks with severe behavioral problems, okay? I mean, that's, once again, these are individuals, and it's not that everybody does, but we have a lot of folks who have severe, bipolar disorder, and when they're in their manic stage, will be, what's a good term? A nightmare here, and I'm getting a lot of nods in the audience, so you know what I'm talking about out there here. And, the problem with that is, and this is another thing to go back to this, I've seen too many trusts, and we get a lot of referrals here with family members who've been named as trustees of a special needs trust where it's just turned their life upside down, and I've seen it ruin people's lives, especially siblings here. And so the problem with it is, where shall we put them? What can they do? If we put them on the advisory committee and the trustee denies a distribution, oftentimes what they'll end up doing is just keep hounding the advisory committee until they drive them out of their minds as well, if that's the behavioral issue we're dealing with. So oftentimes we'll name, so you might name like a son or daughter or family member as what's called a trust protector. What's a trust protector? A trust protector has two roles and two roles only. They actually usually don't get involved in the day-to-day management, at least directly here. And they have the power to hire and fire and amend if the laws change. I'll give you an example of a case. I had a case where we actually did a program for NAMI, why you shouldn't make your daughter the trustee of your bipolar son's trust. It's not a good idea. And she was there and she said, Mr. Day, I was sitting there with my mother and I felt, who had a terminal illness, and she said, I felt like you were talking to me. And I said, well, in many ways I was. And she says, my sister has, back then it was manic depression, now we call it bipolar disorder, God knows what it'll be in the future, it's the same thing. And she said that If I become the trustee, it's going to be a nightmare because not only does my sister have problems with her bipolar disorder, she also has a little problem with methamphetamines, if there is such a thing as a little problem with methamphetamines. So she got her mother to change the trust. Mother passed away shortly after that. The trustee took over a guy named Fred Isaacs, who passed away years ago, a fantastic trustee. First thing happened is the sister who became the beneficiary made a demand on Fred that to buy an RV. So she and her newly found boyfriend, who I think was the actual person who was cooking the meth here, could go across the country in the RV here, and that's what Mom really wanted. And Fred said, no, we're not going to do that. First off, it would really help if you got a driver's license, and if you could actually be clean and sober for a period of time, and then maybe we will get you an automobile. This just set her off. So she called her sister here and said, this is not what sister wanted. This is not what Mom wanted. We need to get rid of this trustee. What are we going to do? And the sister was able to say, I don't know why. Well, this part was not true. But Mom did not make me the trustee. Fred's the trustee, so you're just going to have to do what he said. She called me up and then sent us a big box of fruit. We do work for fruit because she said if I had been the trustee, she would have hounded me until I would have given in. Right? So once again, there is a role for family, but this is something to think about. Do you really want to put her on the front line? Now, here's the thing that comes up, and here's a question that if I were allowing you to take questions, you'd probably ask. How much does this cost? Because, a lot of these trustees, they do have a bad habit of charging, right? So trustees, corporate trustees tend to charge a percentage. It's going to be somewhere between 1%, 1.5%, somewhere around that, okay? But the problem with a lot of corporate trustees is a lot of their minimums, like for instance, Wells Fargo, who has a division who does special needs trust, which I actually feel, and by the way, even if you hate Wells Fargo, it's not Wells Fargo, it's the people doing the work here. But they have a group, which the group today is doing a fine job, but they have a minimum of $1 million, which really means they need $1.5 million. And you might go, I don't have $1.5 million. There's others that might take less here, and maybe that doesn't really work for you. A private fiduciary tend not to have stated minimums, although they oftentimes have a practical minimum. They will charge by the hour. They'll range anywhere from $100 an hour to I know a fiduciary who charges $180 to $200 an hour. Here, if you're doing it by end of the hour and it's it's done correctly, that could be a lot. It could be minimal. So that's one of those things in your situation. You go back to this. When you're hiring a law firm, whether it's the Dale Law Firm or another firm, you're hiring the experience of the law firm here. And so in your situation, as you're dealing with this, you want to ask them. You might say, God, I would love to do that, but what I can really afford to do is leave a house for my loved one to live in, and let's say maybe $250,000 on the side to make sure that the roof doesn't leak here. And housing really is one of the biggest issues we deal with. And in that situation, it might be that you might want to end up having a family member be the trustee, but really narrowly tailor that trust, basically say, and especially if you're doing this with a house, you've got to have money on the side because eventually they're going to lose the house. We probably evict 3 or 4 people a year from the home they're living in because they were left a house but no money to keep the house up. What do you think is going to happen to the house? We're going to lose the house, right? Mm-hmm. So you might do that and really nicely tailor that thing to this is what we're going to do here. And then if they need some advisement, then they can hire it by the hour. So the other thing you might consider is you might say, Mr. Dale, that sounds good about the professional trustee, but I want my really smart daughter, who's an attorney, who's probably the worst person you could choose. But anyway, my really smart daughter or son, although it's always the daughters, who's going to be the trustee here, and I'm going to do this anyway. Well, as you do this, at least have it drafted that if it turns out it's more than your son or daughter can handle, language in the trust that says they can delegate it to a professional trustee of their choosing. Now the last one really quick to mention, and we do have, and we'll make sure that in the information we send you, we have a program called How to Use a Pooled Trust with the Special Needs Trust. Let me mention to you what a pooled trust is. And there's many different kinds of pooled trust. I happen to be the trustee of the Golden State Pooled Trust here, but there are other pooled trusts. There's the proxy parent or plan, there's secured futures, there's many pooled trusts out there. I happen to like the Golden State Pooled Trust here. What a pooled trust is in a traditional sense, the way you normally use a pooled trust is there's a master agreement, and instead of doing your own trust, you you sign what's called a jointer agreement, and you create an account. So, sounds good. Isn't that the way to go? And then you don't have to go through all the hassle and the expense of creating a special needs trust. Well, why wouldn't I do that? Well, here's the problem. Even with the pooled trust in California, none of them have been around that long, and pooled trusts change from time to time. They're run by nonprofits, and like most nonprofits, they're only as good as their board and the people that are working there. And once again, we're looking for the long term. So here's what I like to do, and we actually have language with this. Pooled trust can be very good. The nice thing about a pooled trust is they will tend to have hundreds, in some cases thousands of beneficiaries. And so oftentimes they may have services here, and what they're able to do is they're able to spread the cost of those services across all their different beneficiaries, and in some cases there can actually be some savings, and there are also some pooled trusts that have their own care management, maybe at a lesser cost. So instead of, once again, joining through a jointer agreement, our suggestion is you create a special needs trust, and in that special needs trust, there's language in there that says that I would like the trustee to be the Golden State Pooled Trust, comma, or a private professional fiduciary, corporate trustee, or pooled trust of my either advisory committee or trust protector's choosing. And then in that trust, basically have an advisory committee or a trust protector. Why? Let's say for some reason, and we're talking specifically about the Golden State Pooled Trust, but it could be any pooled trust. If for some reason that trust is not properly serving your loved one, or maybe there's a better program that does better work at less cost, then we have a system that would allow those funds to be able to be moved from your trust to another trust. What's the right situation for you? And the answer is, that's the joy of going through this planning, because I have no idea here. And part of this is, once again, Jennifer and her drafting team will work with you. And really, I really encourage you, it's not a one-way discussion. It's a two-way discussion. Your job is to teach Jennifer and Lysandra about what your objectives are, what your resources are, not only financially, but also family, circle of support, and that kind of thing. Their job is to teach you about not only options, but what they've seen that's worked and what hasn't worked. That's the value of working with an experienced law firm, whether it's the Dale Law Firm or another law firm. Here's the last thing about our 4 parts, and then we got a few things to cover, and then we'll get into questions. Funding the trust. And this one part will be short, but it doesn't mean that it's not important. Consider the trust as the vehicle, the trustee as the driver, but if you don't put some fuel in that trust, if you don't fund that trust, it's not going to go anywhere at all. So part of this is that when you're doing this planning, it's not just planning during your lifetime about investments and that kind of thing. That certainly is important, but ideally, you know, including if you're working with an investment advisor now, including that investment advisor in your planning process is incredibly important. It's important for a couple of things. And, you know, once again, we like working with investment advisors, and we like teaching them about strategies we've worked with that we think work really well. Now, a good investment advisor should be more than just a good stock picker here. They should know what your values are, what your objectives are, and that sort of thing here. The other thing with it is, and once again, I was just talking to an investment advisor today where they're moving funds over. One of the biggest problems with special needs trusts, let's go back one step. One of the biggest problems with living trusts and special needs trusts is people go to all the trouble of they set these trusts up, But if you don't take your assets and title them into the trust, make the trust the owner or the beneficiary of everything during your lifetime and upon your passing, the trust is not going to work. A good investment advisor is going to work with you and make sure that all of your assets are properly titled into your trust so you don't have problems. Here's the other thing if you're working with an investment advisor, and this might help you in choosing a trustee. If you have a good investment advisor who really knows your values here and has been really good with your family and understands the challenges you've been working with your disabled child, why should we get rid of them after you pass away? They still have a value to the team. Many, especially private professional fiduciaries, including the private fiduciary that's in this room here, will work with your investment advisor unless they're a complete putz. Okay, so you don't work with putzes? No. Okay, but as long as they're not day trading with their money and doing things that scare the fiduciary to death, they'll continue to work with that investment advisor. If they served you well during your lifetime, why not keep them on? They still have a value. Something to consider. Last part of the process, just here, and one of the things that we will send you here in the link, Amy will send you, is a link to updates and reviews of trusts. So we have a video called doing a self-check on my special needs trust and doing a self-check on my estate plan, and that will kind of guide you through this. A question I often hear is how much I have in my child's trust. I've kind of covered that. Or how often should I have my trust reviewed by my attorney? And the answer is that all attorneys give or should give is it really depends. So now that's not a very satisfying answer here, but let me give you some guidance, okay? As far as the laws have changed with special needs trusts, there hasn't been anything major in estate planning where we've needed to do a full change as far as planning, as far as major changes in the law. Very, very few things have come up. What we really suggest is a self-check. Now there's a couple things here. One is that I wrote an article for the Special Needs Alliance called Updating Your Special Needs Trust to begin with a self-check. We'll give you a link to that, but we'll also give you a link to a video that goes through how to do a self-check yourself. My suggestion is once a year, take a look at that thing. You can pick your child's birthday. I have a client who says that we do it on the day we sign the trust because I remember the day that we signed that really big check to the Dale Law Firm, and that's a moment I'll never forget. Go, if that's something that got your attention, that's fine too. Here, whatever it is, not only is your child not static, nor is the trust. So with an annual review here, you can take yourself, and once again, it's something you might sit down with your financial or tax advisor here that'll help you with that. Once you perform that self-check, you'll be able to determine here if it's time to update your estate plan and your special needs trust. What do people change? What they normally change, and our process is so thorough. Rarely do we change much in the trust. We change trustees, we change advisory committee members, although the way we work is we have you name some core members who are going to be on the advisory committee, and then have you keep a schedule of the other folks so you can change it, so that like if Uncle Bob got indicted here by the Mueller probe, you go, maybe we need to wait 8 or 10 years until he gets out before he's back, or something along that line. Whatever the thing is, things are going to change, and that's just not the kind of thing where you want to spend your dollars on. And people change, remain their beneficiaries. So let's go through a couple of things here about drafting our process. So here's our process here. This is actually out of order. I'll go through the process here, but then I want to go through a few key things when we're dealing about planning for a person with mental illness. So this is out of, but since this is the way we put it in, what we're going to ask you to do is fill out the intake sheet. And I believe you have an intake sheet. No, you don't, because I don't see one. We'll see that everybody gets access to an intake sheet before the first appointment. And as we're going to show, we actually bribe you to do this correctly. So if you want the discount, you got to fill out the paperwork, okay? To meet with Jennifer with the representation agreement, and then we normally take a 50% down payment, okay? I'm a behavioral nurse. I believe in behavioralism, so we take half now, and we take the other half when we've done our job. So it's like, we want you to say, good job, and here's a check. That's the kind of reward we're looking for. Review, what we do with it is they try to turn it around as quick as they can, and they do an initial draft of the trust, and they send it to you in a PDF form. The vast majority of our clients, they go through a review. It usually takes a half an hour, 45 minutes. There's no set time in it, and it'll highlight what you need to go through, because the goal is not only to make sure the trust is correct, the goal is to make sure that the important parts of the trust you actually understand. And the last part is to sign the final document and pay the remainder of the fee. So, I want to go through, since our subject is dealing with folks with a mental health diagnosis, I want to go through some key planning things here, and then we'll start taking questions. So, first off, what's unique about planning for somebody with a mental diagnosis? Okay, the first thing is there are very few programs for folks with mental illness, unlike those with developmental disabilities. And you know, the problem and the challenge, I mean, and that's not just for the special needs trust, that's something that most of you probably are going through right now. And so, you know, really being in touch with the programs that are out there is incredibly important. And also, you know, the fact is that, for instance, for many folks who are not fully conserved and that kind of thing, you know, being able to understand what kind of board of care programs and the cost and the benefits and all that, and the problems is really important. And I know this is one of the biggest challenges we deal with, unlike folks with developmental disabilities, where they're guaranteed by the state to have appropriate services. Now, if you are a loved one with somebody with a developmental disability, you're probably not incredibly happy with the services that you're getting. Thank God your child doesn't have a mental health issue, because a lot of the people in this room would kill to get the kind of programs that the developmental disability community has, right? And that's not to take away from the DD community, it's just a fact of life and a sad one. It's common for the beneficiary to have wild swings in circumstances and behaviors, and I'm going to cover that a little bit more in a few more slides. It's really difficult to find a trustee or an advisor. Now, because of the nature of our practice, we have a number of trustees that we do work with, who do work specifically with folks with mental illness. I will tell you, they're very few and far between, and we absolutely appreciate them here, because this is not the easy group to work with, generally speaking. Here, and really, when you're working with trustees, one of the things as we start talking about this new program called the Life Passage Planning Program is to be able to ease a lot of the challenges, which is dealing with a lot of the behavioral social issues of folks. And this is where care managers and this new program comes in, because once again, most of these fiduciaries, they're not social service professionals, they're fiduciaries. They deal with trusts and things like that, and they're not mental health professionals. Family dynamics can be challenging, you know, and the issues with that, you know, often, you know, once again, that doesn't just end when you pass away. And so, you know, one thing that's really important as far as I'm concerned is we go back to the whole concept of community program here, is that the goal is not just physically having people in the community, it's really trying to have as much normalcy as possible here, and ideally we want to have a situation where we can maintain good relationships with your child and family as best we can, and so that's a challenge often. Substance abuse or self-medication, call it what you like, is a really common issue, and that's something that can be something that's a real challenge, and that's something that you just can't ignore, even though it's a challenge to deal with it. It's one of those things that you just really have to address as you're doing this planning. There may not be an ideal answer, so if you're thinking that you're going to come in and do your planning and somehow you're going to walk away, with an answer to every problem you have. That's just not reasonable. As part of this is just trying to set up a system, what we like to call a private social service system that's going to do its best possible within the resources, not only your resources, but the resources of the community, and and the resources within your family, not just financial but personal, to try to get the best result possible. I know one of the biggest issues that I deal with is changes in circumstances. So, and like, for instance, providing for somebody with Down syndrome, where there may be variations as time goes on, but the challenges are, they're not going to swing wildly. With folks with mental illness, it's very common that there'll be long periods of time where maybe they're doing well, and then periods of time when they'll have a break, and, it's like everything else. Good behavioralism is trying to do your best to ignore bad behavior, at least not pay as little attention as you can, and reward good behavior. So, this is something we want to make sure we do. As far as we do that, we want to make sure that we do create a trust that can adjust. So the trust needs to be flexible, and I'm going to show you some language in a minute that would probably, and in fact, Amy, if we get a chance, I'm making a big list of homework for myself, which means Amy's going to be doing a lot of work here. But we'll try to send this in language so it'll be easier to see here. But I'll give you some language that we typically use to be flexible. And so, once again, we need to be realistic that your child may do very well for a long period of time, but, even with substance abuse here, the thing with it is there's always the risk. There's always the possibility, in some cases almost the certainty of recidivism, and we just need to deal with that. Don't back yourself into a corner. So once again, flexibility is the key. We need to be realistic, okay? And this is part of going back to when you're dealing with Jennifer and her drastic team. Ask her, is what I'm asking the trustee to do, is it realistic? Is this something trustees can really do? And it may be that it actually isn't. And the other part of this is protect your loved ones from taking on responsibilities they're not prepared for or that could be damaging to them. I personally believe that family is a very important companion. So I'm not saying with family, keep hands off. What I'm saying is ideally, what we want to do is have family who are, being able to have as normal and as nurturing a relationship as possible, despite the mental illness here. And it may be one of those things where we want them to be in a supportive role, but not dealing with all the different crises that come up, which can just really destroy situations. Now here's the language that I referred to here, which is, we often put this trust in and it has to do with dealing with changed circumstance. So even though, once again, unless you folks have incredibly good eyesight, I doubt if you can read that, but here's what it's basically saying. And here's the question you might be asking, or that Jennifer might ask you. Under what situations would you want to tell the trustee that I want this trust not to focus so much on preservation of benefits and being able to be restrictive, but what I'd really like it to do is that when my child is doing well, I would like to give more latitude, more control to my child. And when things aren't going well, I want to draw that back. Now, how would you measure that? Well, there's a couple things to measure. So what it actually says here is, now for many folks, and this is just suggestive language, okay, is employment can be a really good key. So what this says in this case is, if my child has been substantially gainfully employed, which means working to the point that they can actually support themselves. Doesn't mean they have to make a lot of money. Money's good. But at least, working oftentimes and being able to hold a job is kind of a good measurement. It's not the only measurement. So in this case, it's saying for 36 months, my trustee is authorized, but this is important, but not required. If it was required, then we would lose our asset protection, to distribute an amount to the trust. Now in this case, what it's doing is it's saying that what I want you to do is give him or her 6% a year of the trust principal. And there's any different number of ways you can do this a year. Just give it to them and see how they do. In making this determination, it's saying that I also want you to consider this thing. the availability of medical insurance as a replacement to the Medi-Cal. Well, that certainly is important. If Medi-Cal is their only way of doing this, based on shortage of assets, well, then we've got a problem. The likelihood of John Smith here requiring needs-based benefits in the future. Okay, but you can, with these trusts, you can turn it on and turn it off. Protection from current or future creditors. Okay, so it may be that they're doing these things, but if turning the money over to them just means that the creditors are going to take it, maybe that's not something we want them to do. And the ability for them to manage their assets, right? So, I mean, our goal is not for them to be dependent on this for the rest of their life. Okay, so now the last thing I want to talk about, and then we're not going to go through the last section because we're running out of time here. But I want to talk about care management, but I also want to talk about a new program, and you will get a link to some materials about what's called the Life Passage Planning Program. What's the Life Passage Planning Program? In a nutshell, our primary way of dealing with a lot of the social needs of our folks with disabilities, especially those with mental health disabilities, are using what are called care managers. And care managers are wonderful, and they're usually social workers, they may be RNs, they may be they may be marriage and family counselors, but normally these are folks with degrees and all that. Sounds terrific. What's the problem? They tend to charge somewhere between 150 and 180 bucks an hour. Now, I think they do a marvelous job, but you can imagine how you could run it through a trust pretty quickly at 150 to 180 dollars an hour. We've been looking at the Golden State Pool Trust for some time of how can we find something that's maybe better geared, and the care managers tend to focus primarily on seniors, people like me. I guess technically I'm 67, so I'm a senior here. Well, no, I'm not technically 67, I'm 67 here, so I'm a senior too. But the needs of seniors is similar but not the same as somebody with a mental illness. What the Life Passage Planning Project is in a nutshell is it's adapting programs called independent living and supported living services programs that have only been traditionally available for folks that have intellectual and developmental disabilities, regional center clients. This program, which is now operational in Alameda County and parts of Contra Costa County by a group called East Bay Innovations, in San Francisco County and Marin County by a group called ICS, and soon it's spreading across the state. These are professionals, and they tend to work for $60 an hour. It's not just the cost. They also know the different programs in the community. I just placed somebody with a serious mental illness in a HUD program where the waiting list, I probably shouldn't be doing this on camera here, where the waiting lists are 20 years. Somehow they got past the waiting list here. A lot of it is knowing the people, knowing when openings come up. It's relationships with these programs. I will tell you, for a lot of folks with mental illness, the Life Passage Planning Program, and once again, I know I keep referring, but I'm not going to do it by name, to a fiduciary in the room who has worked with one of these programs and has had very good results, right? And so it also takes some of the burden off of the fiduciary, so we're not completely burning out the fiduciary. So with that, I'm not going to go through the intake process. What I will do for those of you that are watching, we'll send a link to another program that will take you to how to fill out the intake sheet. With that, we'll take questions from the audience here. If you have some questions, as I told you, we'll do this for 20 minutes if that's okay. I will stay longer, but we're going to try to shut this down shortly after 5 o'clock here for the folks that are viewing. If you have a long personal question, wait, okay? If it's a general question, that's fine. And then we'll take some intermittent questions. Do we have some questions from the internet, Amy?
Not yet.
Okay, and if those are of you that are watching out there, you do have questions. If for some reason the chat's not working for you, you can email Amy at dalelawfirm.com. Any questions? If not, we'll go home. I couldn't possibly have answered all your questions.
I have a question.
Okay, so, well, you have to get in your seat.
Okay.
Okay. By the way, for those of you, you probably know Amy a bit. Amy is our education and outreach coordinator, so not only does she help us put these things together, but she also helps us put together programs. So if you are with a disability group, especially if you have a NAMI group that's interested in a presentation, especially about the Life Path Flying program, that's who you talk to. Amy, what do you got?
I have a question. I've heard you say these workshops several times that your trusts are really long. Why are they so long? What's in them that makes them so long? And is 90% of them the same across clients, and 10% is unique?
Okay, so here's the first answer. It's because I have a word processor and I'm not afraid to use it. That's not why. Okay, the base program we use is a Wealth Counsel Trust. Now, for those of you out there that are not estate planning professionals, you wouldn't know a Wealth Counsel Trust from another kind of trust. The base trust, all estate planning attorneys today use a software program. Now, my mother was a legal secretary, and she said the attorneys did a better job when they started with a blank piece of paper and had to type the thing from scratch. And that may be true, Mom, but that's not how we do it today. Okay, so we all start with the base document. Our base document is what's called a Wealth Counsel Trust. Now, one of the advantages of a Wealth Counsel Trust is the base document, and Amy's right. 90%, I might go to 95% of that trust. That is not a customized trust here. In that trust, it's going to have key areas that are very personalized to you about who's the trustee, what are our objectives, who's the remainder beneficiaries, and all that. The vast majority of that trust is a lot of boilerplate here, and even a lot of the stuff that you would look in the trust, if you went through the back sections of the trust, the powers of the trustee, definitions and all that, if you go through that, and do yourself a favor, don't. Here, it's going to have information about how to handle your oil wells, how to handle your farms, how to handle your professional practices, how to handle toxic property, how to handle all these things. Now, you might say, but I don't have a farm and I don't have any toxic property. Well, you can't be sure of that here and all that. Here's the thing, and this is how I always explain it. Mom always had a saying. She used to say that when I would go to summer camp, which I used to go to summer camp in the Santa Clara Mountains where it was warm, right? But she'd always put a sweater in my suitcase. And I go, Mom, why are you putting the sweater in the suitcase? She says, well, it could get cold just in case, okay? And by the way, one year it got really cold and I pulled out the sweater in the suitcase, right? Well, I always think of this like it's the sweater in the suitcase. Why does it have something about an oil well or a farm or that kind of thing? You never know. I have had clients inherit things they had no idea that was coming and that kind of thing. The other thing with that is, we go back to the Wealth Counsel document, even though we do customized trusts. Every trust is different, not the whole thing. If for some reason, let's say one of our greatest exports in California is Californians. So let's say you decide, I'm out of here, and you do like a lot of people do. I'm going to sell my multi-million-dollar house, which is my 3-bedroom house, right, in Alamo, which, people would be astounded that that's a $1 million house. And I'm going to move to, New York, where, you can get a nicer house probably for $300,000 and all that. So once again, if you do that, if you were to do that and to move to New York, we would actually urge you to take that trust, and we will actually transfer the file, including the soft copy, to a Wealth Counsel member. Now, what's the advantage of using a Wealth Counsel member, especially a Wealth Counsel member that understands the special needs trust part of that, is like when I get a trust document that I don't recognize, I've got to read that stinker from top to bottom, because now I have to go through that trust and I have to understand every piece of this. And I charge $450 an hour. So do you want me charging $450 an hour to read through, a 40-page document, which is going to take me 2 or 3 hours? I would suggest to you no, right? If this gets transferred to a Wealth Counsel member, or an elder council member, one of those groups, then they know that base document, right? When I see an elder council or a wealth council trust, I know that document. So I can go through and I can just zero in on the customized parts of that trust. The nice thing with it, the other reason why it may have a lot of language in it, you look at that and you go, this makes no sense whatsoever. We almost always do a separate special needs trust, and we do that with a living trust. So if you're doing the entire package with us here, and I know one thing that I'll jump to in a minute is our fees. Here, the language, the boilerplate you'll see in the living trust is very similar to what you're going to see in the special needs trust, as well as any other documents we do. Why do we do that? If there is some sort of need, and we have the same beneficiary that's in each trust, there's a thing called the doctrine of merger that says if all the powers and everything is essentially the same, if we have multiple beneficiaries, we can slap those trusts together so people don't have to look at a half a dozen different trusts, and things can be simpler. So that's how we do it, and there we go. Let me just do this and see if this works. The thing that I did skip is our fees, So let me cover this, and these are our fees, okay? And then we will take your question. Okay, so our fees here, here's what we charge, okay? So if you're just doing a special needs trust, so let's say you have a living trust, and if you own a home, you need to do a special living trust, but we don't have time to get into that today. And the reason you need to do a living trust is to avoid probate, because California probate laws are something you definitely want to avoid. Okay, so our normal fee is $3,000 to do the special needs trust. And if you already did a living trust, what you would do if you worked with another law firm, and if you're already working it with another law firm and they've done your living trust and you're happy with them, there's no reason to replace them. I'm happy to review it. If I find something needs to change, happy to do it. So with that, we charge $2,500 if you attend the workshop, because Jennifer will probably spend at least an hour less with you, if not more, because you should be better prepared. If you're, once again, if you're doing a revocable living trust, we charge a flat fee of $3,000 for that. But what we do charge is we do charge a package. Oh, the package here, if you are a single person of doing a living trust and a special needs trust, is $3,000. Let me back up. The package for a single person who's doing a living trust and a special needs trust is $4,000 if you're doing them both together. And if we're doing it for a couple, it's $4,500. So basically we would charge you $2,000 more for a couple and $1,500 more for a single person. We're not talking about first party trust today, so why don't we not even go there? Part of that is, and it's certainly important to go through those fees before you do this, and these are our fees. Whatever somebody else charges, that's what they charge. There's no set fee out there. Some offices charge more, some offices charge less. Here, this is what we charge in order to keep our doors open. So going back to the fees, that's how we work. We had a question in the back, and if you could speak up, that would be terrific. And just one question, DJ, tell me if you can hear her.
So I actually had two questions, but the question that I have was regarding the different options that you suggested, the Model 1 through 4.
Yes.
Could you speak up?
Do your best, or I'll repeat the question if you can.
On those different options, is that what the intake person helps you to determine what is best for each family?
That's what they do. And here, what we actually do, like I say, because of time, I'm not going to go through this all. The part of the intake sheet that we normally have you fill out, and we do this purposely, is we ask you, who do you think should be involved with your family? And here's why. What we don't want to do is we don't want to set expectations before we deal with this. So the question was, with the different options here that we suggested, and they're not the only options, but those are the ones we normally kind of suggest. How does that actually work when, you're going through working with Jennifer and her team? What we kind of ask you is, who do you think should be involved with your child? What's their relationship, and what's their strengths and what's their weaknesses? and by the way, they will never see this because you probably don't want them to see it here, and that will kind of help you. When you sit down with Jennifer, what she's going to do is she's going to talk with you and say, well, let's talk about trustees. Have you thought about trustees? Now, you may be thinking about here a professional fiduciary, you may be thinking about a corporate trustee, you may be thinking, I have a loved one and I think they can actually really do it. And, you know, she'll work with you. And if that's what you want to do, that's what she will do. And, you know, once again, you're the client and all that. But she'll also discuss with you, you know, if you're going to do this, this is typically what we're going to do, is that, you know, I know with some family members, there may be a close bond between siblings. And I can't tell you how many times I've been told that, oh, the siblings will always live in the same area. No, they won't. You have no idea. You know, the sibling trustee could fall in love with somebody on the East Coast and boom, they're gone, right? There's any number of things that might happen. So she's going to challenge you, but, you know, once again, not in an adversarial way, because we go back to this. You're buying her experience. You're buying our experience, not the experience of the firm. And it really depends on this. The other thing she'll do is she might say, I absolutely want Morgan Stanley as the trustee. And maybe that's okay and maybe that's not. Is that practical? She's going to talk to you about whether that's practical or not, right? And it may be that that's just not really practical. And even if you're going to do that, we need to make sure that when the time comes, we have a trust that actually is going to function. So you had a second question.
So the second question is that I kind of see that there's a lot of people that are being included into the special needs trust with a lot of money paying out for the service that these people are providing.
Yes.
But in reality, I mean, a lot of the money is actually being dispersed and taken by all of these professional care people and advisory committee people, and yet the beneficiary may not be really getting any distributions because they're not dead yet. I mean, they're
right.
You know, the family, the trustee hasn't been invoked, right? So you're paying out quite a bit of funds for this. Can you comment on that?
So let me kind of repeat the question in a different way. Isn't there a danger we're going to spend all the money on professionals and advisors and all of that, and wouldn't it be nice if we really focused on trying to get as much as we could to the person with the disability? Does that basically say what we're trying to do? And okay, I have a couple of responses to that. That is a concern, okay? And I will tell you now, most advisory committee members and trust protectors, most of them don't charge. Some do, most don't, although I actually suggest that you be really careful. There are some situations that if you have an advisory committee or a trust protector who's putting a lot of work into this, there's probably something wrong, okay? I mean, if what they're going to do is advise on every single distribution, then what's really the point of the trustee in the first place, right? I mean, at that point, we might as well just make them co-trustees. One of the things that we kind of cover, and when you get the links, we have something about running an advisory committee that actually functions. And what we talk about is putting together distribution plans, minimizing the involvement of the advisory committee and reducing their time. Actually, for most trustees, if we have an advisory committee or trust protector who's involved with the trustee, even on a weekly basis, we probably have a non-functional trust. There's something wrong here. So along that line, my preference, if there's a behavioral issue here, is not to do an advisory committee, to do a trust protector here with a care manager. Let's talk about care management. Let's talk about trustees here, and let's talk about the life passage planning program. First thing I'm going to tell you is there's an expense, and it's significant. With the options as we have it today, especially with mental illness, it's the price of doing business. If I could find a way not to have these expenses, believe me, I would. And, you know, for instance, this is one of the differences between developmental disabilities and mental health. In developmental disabilities, and if you look at our website and the Achieving Independence YouTube channel, you'll see tons of stuff about how to maximize your IPP. There's no point in even telling you folks what an IPP is because it doesn't apply to you. So there's a guy named Jim Hike who talks about how to basically maximize services and all that. And I know there's somebody in the room who's been working with ICS about how they maximize services and all of that, And if we can get the regional center to pay for it, of course that's what we want to do. That's not an option for us. So sometimes being realistic, I think it would be unfair to tell you that the costs aren't going to be significant. There's a difference between significant and outrageous, right? And the goal really is, how can we balance that out? And sometimes you've got to make some really pragmatic choices, because see, here's the other issue that comes up. If we're planning for let's say, and by the way, the insurance industry loves you people. You know, there's Mass Mutual, Merrill Lynch, they all have insurance divisions out there. And I'm not saying this is a bad thing, but you know, a lot of people, like, you get down to how much should I put in the trust? As I told you, it's hard to come up with a number, but you know, $1 million's a nice place. And you might say, I don't have $1 million, it's not going to happen. And this is where, you know, insurance can come up. Now, I'm just an attorney here, as far as, you know, me being able to tell you how much insurance, what kind of insurance you should buy and all that. I can give you my impression, but I'm not a professional in that. But, you know, for instance, you might buy a term insurance policy or something to cover that cost, at least for that. Now, let's just say, for sake of argument, you have a 17-year-old and there's $1 million in the trust. And actuarially, we got 70 years to go. Well, what we like to do is we like to do what's called a distribution plan, whether it's the Golden State Pool Trust, or we're working with Herb Thomas and Associates, or we're working with Julie Minnick or Wells Fargo or any of the trustees we work with. We like to do a distribution plan to figure out what the expenses we're going to spend, including how much are we going to spend on care management and how much are we going to spend on trustees. And it may be that we're going to, you know, by looking at those numbers, we may look at that and go, this is just not working. And we may have to make some real pragmatic decisions about what we're actually going to do. Let's say we're planning for a 50-year-old. Okay, well, now that's a little different when we have $1 million. Not that we're on easy street yet, but now, you know, we're looking at, you know, 27 to 30 years, although people have a bad habit not dying when they're supposed to. You know, so, I mean, it could be that Kathy could live for 100 years, but we kind of work with actuarial numbers and that kind of thing. Well, you know, that may be a somewhat different situation. You know, we try to keep, so here's the thing that I would look at, because, you know, I share your concern, because we review a lot of trusts, and we do a lot of court-monitored trusts too, and they have the same questions. This is where, you know, on our quest on how to better serve our clients here, this is why we worked on developing this life passage planning program, not only to bring the cost down, but see, here's the thing that we're working with, and it's not just the cost. If we use the life passage planning programs, and what these life passage planning programs are, these are programs that have been around for 30 years, and they provide essentially every piece of support that's necessary as far as overseeing and finding those supports that are necessary for somebody living in their home. It's only been available for folks with developmental disabilities and autism. Oftentimes with a crossover to mental health, but never totally mental health, and this, now we're doing this privately. By doing this at just dollars and cents, at $60 an hour, if we're using a private professional fiduciary, we're probably going to watch the hours of the fiduciary go way down. So what we've seen is by using these programs, we can see the fiduciary costs go down. You know, sometimes we just have to look at what's practical, and we may not find the ideal situation. Like anytime you're dealing with mental illness, we have to make pragmatic decisions, and it may be that we can identify needs that we just can't practically provide. The last thing that we have come up with is, depending on the situation, sometimes the goal is to get as many goodies and things to them as possible. But I have to tell you, with a lot of things, I think the biggest thing lacking in our communities is a lack of appropriate case management by our government and county programs. In fact, I know of some are going to be watching, I know of no community programs I know of that provide what I consider a level of oversight that was promised when they shut down the institutions. And I lived deinstitutionalization. I know deinstitutionalization. Yes, we do have programs where primarily the biggest thing we've been spending money on is care management, is oversight, is that, and we're paying for it privately, which the government promised they would give it to us. That was the bargain. Shut down the state hospitals so we would provide well-funded, robust programs in the community, and they did for about a decade, right? I won't go into why because then we get into politics. Okay, but, you know, we go back to this. I have some trust where I would say, and for our fiduciary, you have trust like this, where maybe the majority of the funds are being focused on case management. You know, the thing you have to look at is, maybe that makes sense in your loved one's situation. Maybe that's an abhorrent thing, and it really depends. And that's why you need a checks and balance system to do with that. So I bet you that's not a satisfactory answer, but it's the truth. I want to thank you for watching today. For those of you here who would like information about future programs, please email Amy at dalelawfirm.com. And with that, we're going to end the webinar today. Please consider not only joining your local NAMI, but please consider in your estate planning, leave them something, okay? They are the most important organization out there when it comes to advocating for persons with mental illness. Thank you and happy advocating.